simply does not deliver. This dysfunction is not accidental, and we have criticized it heavily, and we shall continue to criticize it for far too long until we see positive change. It is a dysfunction engineered to serve entrenched economic and political interests that are usually not openly interrogated at forums like this one. The radical new bar was formed to challenge and dismantle these interests and to disrupt and disturb this kind of status quo. To be radical is to go to the root of the problem and begin to solve it from there. It is not extremism. It is very common to see a radical and mistake them for an extremist because their forms of expression and presentation are the same. But radicalism comes from the Latin word radix, and it means root. A radical is one who goes to the root of the matter and pulls it out by its roots. Radical solutions often feel extreme and cause extreme reaction to those who receive them and must act on them, but they are not extremist and should not always be taken to be so. Extremism is a mindset where a person always simply wants to demonstrate how different their views are from another person, and moreover to the farthest degree possible. This is not radical, it's just extreme. Many extremists are mistaken for radicals and vice versa. I am a radical. My colleagues in the governing council of the Radical New Bar are radicals, but some in the government are extremists, and we have just witnessed that today. Our intention remains to compel power in this country to enable the delivery of justice as a constitutional right. This must apply to the highest ranking individuals and the most ordinary citizens. The Ugandan prison system is heavily congested. Sentencing and incarceration have become arbitrary, wielded as tools of oppression and rather than justice. You've just heard the Chief Justice threaten me with, sentencing and incarceration. More and more imprisonment in Uganda results from poverty, it results from political opposition and offending the powerful. We have said this before, that the practice of law must be free to deliver justice to Ugandans who are suffering land grabbing, bad employment conditions, racial discrimination, sexual harassment, stolen elections, corporate theft, and unjust taxation, among others. The justice seekers. We are the voices of the justice seekers. But we are beginning, and today, or this month, we have begun our campaign to see that every imprisoned Ugandan who is entitled to bail gets it. This will go a long way to decongesting the jails, reuniting families, reorienting judges and magistrates, and exposing the interests profiting from this misery. The judiciary's reliance, however, on the power of contempt to shield itself from critique is an indictment and not a defense. The offense of scandalizing the court is a colonial relic. It's a relic of colonial oppression, long discarded in democratic societies. Why do the Ugandan courts want to continue holding on to it? The courts should expect scrutiny, not silence. The modern judiciary, if it's remained relevant, it must embrace dissent, not criminalize it. To my colleagues at the bar, the fight is not yet over. The Radical New Bar is not a moment, it's a movement. We will be here long after the faces on the bench have changed. We will be here until the judiciary is truly transformed. If the judiciary wishes to contribute to Uganda's development, let it begin by acknowledging its failures. Let it embrace the people's anger and not suppress it. Let it earn legitimacy and not demand it. And above all, let it discard the tools of colonial suppression and stand boldly in the light of accountability. We, the Ugandan society, present no apologies. We will not be silenced, and we will remain an independent bar now, today, and forever. Unapologetically radical, unfalteringly bold, and irrevocably committed to the fundamental principles of justice, accountability, and free expression. Thank you.
No apology.
No apology. This is a time of reckoning. The judiciary cannot insulate itself from the realities of the country. The courts exist not to be praised, but to serve. The Ugandan people have been aggrieved by inefficiencies, corruption, and selective justice for far too long, and they are justified in their anger. Their voices, whether harsh, unfiltered, or piercing a necessary check on judicial power. They are not an attack on the institution. This is feedback from the taxpayer that must be welcomed without any misgivings. The bar does not exist to soothe the judiciary and its sensitivities or the sensitivities of its judges, not offer applause. It exists to hold it accountable and to defend the courts and the judges from executive overreach, interference by special interests and other threats to judicial independence. However, we are witnessing, and we have just witnessed, increasing aggression and animosity from sections of the judiciary, including its top management, against not only the bar, but also the Ugandan people. This is characterized by a pattern of injudicious verdicts corroding public trust and arbitrary reliance on the power of contempt, a colonial relic long disregarded in the global north, but still used to stifle dissent and punish criticism. A judiciary that responds to criticism with repression and intimidation only reinforces its illegitimacy. The recent Supreme Court ruling declaring the trial of civilians in the General Court Martial unconstitutional is a welcome vindication of the rule of law. Yet the stain of the judicial excess remains, exemplified by the tragic case of Ivan Sebaduka, a litigant who was imprisoned for simply expressing an opinion about this very institution, the Supreme Court of Uganda. That imprisonment stands as a permanent scar on our judiciary, a reminder of an era that must come to an end. We are all peace-loving Ugandans, and we should not have hatred for each other. As the radical new bar, we have been and we remain solely concerned with justice, the matter of justice as a whole. Justice is a universal, human, constitutional, and legal right. Without it, society is neither stable nor productive. No justice, no peace is not merely a slogan, it's a statement of reality. No justice, no development is the harsh truth that we must confront today as we inaugurate the new law year under the theme positioning Uganda's judiciary to contribute to social and economic development. Uganda's justice system is a leading demonstration of the general crisis of governance in the country. It simply does not deliver. This dysfunction is not accidental, and we have criticized it heavily, and we shall continue to criticize it for far too long until we see positive change. It is a dysfunction engineered to serve entrenched economic and political interests that are usually not openly interrogated at forums like this one. The radical new bar was formed to challenge and dismantle these interests and to disrupt and disturb this kind of status quo. To be radical is to go to the root of the problem and begin to solve it from there. It is not extremism. It is very common to see a radical and mistake them for an extremist because their forms of expression and presentation are the same. But radicalism comes from the Latin word radix, and it means root. A radical is one who goes to the root of the matter and pulls it out by its roots. Radical solutions often feel extreme and cause extreme reaction to those who receive them and must act on them, but they are not extremist and should not always be taken.